actually going to review 4 of them. Then we'll kind of nail down on the specific changes that are related to juvenile defense, and then also add in some tips and strategies for you so that you can address some of these changes in the courtroom. So the 4 bills that we're really going to focus on today are Session Law 2023-114, that's also been known as House Bill 186, that's entitled Juvenile Justice Changes. It has the bulk of the changes that we'll talk about today, and we'll spend the most time on that. But just to preview it, there's some changes to transfer, some changes to interrogations, and some changes to something like public disclosure of juvenile information. There's a Session Law 2023-75, also known as the Pretrial Integrity Act. If you are an adult defender, you probably have heard about this. You may have even been seeing it happen in practice because it's been in effect for a little over a month now. But that has to do with who has the ability to set bond, in some cases for folks who are out on pretrial, and then for very serious charges initially. There's also Session Law 2023-78, School Threat Assessment Teams, that talks about the implementation of those threat assessment teams, and Session Law 2023-106, which are the Parents' Bill of Rights. That has to do with a lot of things, but the part we'll focus on is the disclosure of gender identity and sexuality information to parents. But I'm going to turn it over to Eric, who will start discussing House Bill 186.
Thanks, Yolanda. So this bill was really a combination of several other bills that had several different ideas in it. And that's why when you look at it, and towards the end of our presentation, I've got links for each of the pieces of the legislation. You can look and see that there's a whole panoply of different ideas and issues. And again, the reason for that is it was coming from several different directions. What we're specifically going to go over are the amendments to transfer. Some of you might have heard that there was some raise the age amendments, and kind of but some very new ideas, public disclosure of juvenile information, especially when youth are being charged with serious offenses and can't be found. Broadening the list of individuals who can be present at interrogations by adding an individual called a caretaker. There are some other juvenile justice modifications, such as service of petitions and some tweaks on the CCAs that I know everybody's familiar with. Some not insignificant changes to secure custody, and there were also some changes to the capacity. And when I mean changes, what I should say was there's an entire overhaul of how capacity to proceed is going to be done in juvenile court. Now, we'll say this more than one time during the presentation, the capacity to proceed changes are not effective until January 1st, 2025. So at this point, we are not going to talk about those, but we will be talking about those in the future. So don't be concerned. We will get to those at some point down the road, but feel free to look at them in the House bill. Okay. So let's talk a little bit about transfer. Like I said before, there were a number of different versions and amendments to the transfer law. And ultimately, the change that emerged was this piece that says that there's now notice to the juvenile of a true bill. Not really sure what that means. We're just going to be honest with you. Because before, you know, the juvenile was supposed to get notice and the court was supposed to get notice. What we think probably happened was this was an attempt to streamline the process. But technically, the court still has to be notified that there was a true bill for the court then to make findings and order a transfer. So again, I don't mean to start off with an ambiguity, but there you go. We think it doesn't probably have any change to the process. Again, this is, and we'll talk a little bit later, to say these are for offenses that occur on and after December 1st. So maybe early next year we'll get some feedback on this, but we're thinking it probably doesn't have a lot of change. Now, there are a couple of changes, both in transfer and secure custody, that apply to 13, 14, and 15-year-olds charged with a Class A felony, generally first-degree murder, although there's other offenses that are also classified as Class A. And here's one of them. So we all know from the raise the age changes, right, that we had this new indictment process. So now the indictment process is being brought to 13, 14, and 15-year-olds charged with a Class A felony. No other offenses, but you can, in fact, indict now a 13, 14, or 15-year-old for the first time charged with a Class A felony. Okay, next slide, please. So we're going to talk a little bit about transfer. Like I said, it's kind of unclear what this means. We know that since 2019, of course, the pandemic and all that, local jurisdictions have kind of figured out what to do in the process once a true bill of indictment comes down. I did also want to mention, as a practice point, and I brought this up to a couple of legislators, but I guess there wasn't time to correct this. What's interesting about now adding in 13, 14, and 15-year-olds eligible to be indictment is they do not get the benefit of reverse waiver like 16 and 17-year-olds do if they are indicted. So that might be something you want to consider as kind of like an equal protection due process argument. But hopefully this will be rectified sometime in the future. But for now, just be aware that reverse waiver doesn't exist for this group of youth, even though they're subject to the indictment process.
So this next section is probably a section that you all have heard a lot about, but it's the public disclosure of juvenile information. And so what this new part of the law does is allow law enforcement to release information about youth clients. They can release the juvenile's first name, last name, and a photo. Any offense that is alleged in a juvenile petition, whether a secure custody order has been issued, and a statement based on the juvenile's record, nature of the offense, and the level of safety threat posed. The law says that they have to get a court order. There are some exceptions to that we'll go through, but what this new law does is allows for law enforcement agencies to release information publicly about juveniles if they are charged with an offense. What the law requires is that the court makes a written finding in an order that a petition has been filed, that the juvenile is subject to transfer. So what that practically means is that these public disclosures can be made in cases where the youth is at least 13 years old and charged with a felony, because those are all transferable offenses. So they have to make that written finding that there was a petition filed and there's a juvenile charged with a transferable offense. The juvenile presents a danger to themselves or others based on the juvenile's record or nature of the offense, and that good cause exists for the disclosure. But again, like we said, there are some exceptions to that rule, and one of the biggest exceptions is if there is exigent circumstances, law enforcement can release the information without a court order. There are kind of two interesting prongs of this new law, and one of those is that it says that if a juvenile is released before the disclosure is made, so like if law enforcement goes and seeks this order, but in the meantime the juvenile is taken into secure custody, they cannot release the information even though they have this order. But it also says that if they get this order and they are allowed to release this information and then the youth is detained, they have to take all of that information down. But as we all know, it's 2023, the internet is somewhat forever. And so when the information is out there, it's out there. but the law does say law enforcement has to take it down from their social media accounts and all of those things that they control. If law enforcement does decide to proceed without an order initially because there are exigent circumstances, the law also says that they must seek a court order to release the information as soon as reasonably practical, and that information must be removed if an order isn't issued at the next available session of court. So that's what the law says. I think, we can talk about what that next session of available court means. That those are in other provisions of the juvenile code, as well as what does as soon as reasonably practical mean. But Erica's going to talk a little bit more about strategy.
Right. So, as Yolanda has stated, this is a whole new piece of the law. Before this, it was only in very, very limited circumstances that this information could be released to the public. This was, I think, as most people know, a result of a situation that happened in Orange County where a youth had been charged with a double homicide and was on the run, and they couldn't locate the youth. So as a result of that incident, we now have this new policy. We think that when the law says findings, that means hearing. And when the law says hearing, that means lawyer, because, of course, we are appointed as soon as a petition is filed. There's no direction in the statute about how that's supposed to work. So, this is something that you may want to consider talking to your local folks about, like, how is this going to happen? Because if the judge is going to make findings, then there's probably a proceeding. And if there's going to be a proceeding, even if it's just a secure custody order, everybody here has already been appointed because the petition is supposed to follow the secure custody order. Although we're going to talk a little bit about the service of that a little later in the program, because that's also a new change in the law. As Yolanda said, ask the court to remove the information, from law enforcement or any other, dissemination. But we think that's probably a band-aid because this information is going to be out there regardless. And as I mentioned, because this statute emanated from this particular situation, we think that it should be used sparingly, and it really is related to juveniles on the run. As Yolanda mentioned, it's for any offense that can be transferred. So it's a 13-year-old and any felony. Our hope is that it's really for very serious offenses, and they really can't find this individual and not be used every time. But we just can't regulate that. But as attorneys, we can try to limit that as much as possible. So as I mentioned, if you've got local rules of juvenile court, you might want to look at those and see if those are, could be amended, or just have this conversation with DJJ, the bench, and the prosecutors to see if you can work something out. Because otherwise, who knows what's going to happen? Because again, we don't have any direction, so that's a little concerning. And then, if exigent circumstances, I think, is probably subject to interpretation. So the more we can do to help narrow that, the better, because then it's going to probably be used broadly. So just make sure that as soon as reasonably practicable, says what it means, as soon as they can, just to get an order. Don't just go off and several days later say, oh, we forgot we were supposed to get an order. So try to hold them to that if you can.
And Eric, before we move on to the next topic, I can't see the chat, so I'm not sure if there are any questions, but if there are any questions, feel free to butt in, or Berger, Nani, if you see any questions, if you could read them out for us.
Absolutely. Please do. And if you get the shoulder shrug emoji from us, that's because we don't actually know. But we can make stuff up because that's what we're good at here. Okay. So next we are going to talk about interrogation procedures. So this is sort of augmenting something that already exists. As you all know, um, when any juvenile is in a custodial interrogation situation, if they're, make sure I got this right, Yolanda, if they're under 16, then nothing is admissible unless there is a parent, guardian, custodian, or attorney present. But for a 16-year-old, you got to ask. So 16 and 17-year-olds, you're asking. Well, this is now being expanded to add an individual called a caretaker. We're going to get to the definition in a second. But it's definitely broadening the group of individuals for older youth who can be present when they're being interrogated. There is this limitation about they're supposed to contact the parent, guardian, or custodian before they contact the caretaker. We're going to keep an eye on that. But hopefully that's the case, and at least the General Assembly recognize that it's the person who knows the juvenile the best and has their true best interest at heart to try to protect them from self-incrimination in front of law enforcement. So here's the definition. So this comes, if I'm not mistaken, from 7B subchapter 1, the A and D side of things. And as you can see, very basically, it's broad. Okay, it could potentially include a lot of different people. So any person, other than the previously stated person who has responsibility for the health and welfare of the juvenile in a residential setting. Look at the list. That is a lot of people. And it doesn't take into consideration necessarily the length of time this person has been in contact. How long has this person been in their lives? Well, how have they demonstrated that they're a true caretaker? And then you see the next list. And so here's where we think it's very broad. This is basically any out-of-home placement that the juvenile is currently staying. That is a long list of folks. And it says it was school operated by DHHS. I am not sure I even understand what that means, but somebody could probably put something in the chat. Point being is that before, it was somebody who was much closer to the juvenile or an attorney. This broadens it out, and Yolanda was going to talk a little bit about the strategy for that.
Yes, as Eric was saying, one of the things that we think you can do is kind of scrutinize that caretaker. I mean, this may work in our advantage. It could, but we want to hold them to the burden of having the caretaker be someone that the juvenile really trusts, kind of like that local parentis type role. And so the way that the caretaker definition reads is that, that caretaker could be the 18-year-old brother of your client that lives at home with him. And maybe that 18-year-old client doesn't, the juvenile doesn't trust the 18-year-old the same way that they may trust their parent or their aunt or their uncle. And so I would scrutinize that if your client is living in a residential setting, whether or not that person is somebody that they can confide in the same way that they may be able to confide in their parent or guardian. But we can see if that person is someone that really makes that statement voluntary. We also would say hold law enforcement to their standard of having to contact the parent and the guardian first. They're supposed to make efforts to call them and see if they can be present. They can't just go to the caretaker provision like that. So try to hold them to that standard and then make an argument that they didn't follow the procedure. I think a lot of these will still be constitutional arguments that the statement wasn't voluntary, it wasn't made knowingly, but we could put that procedure into that argument and use the fact that maybe this isn't a caretaker that they hold in the same regard as a parent to our advantage in that matter. But I would just think of it practically. You know, your client may feel much more comfortable talking to their mom about this than they might be to their 18-year-old cousin or 19-year-old cousin. There are some things that are in the chat I see. Was there a question?
Yeah, I'll read it. This is from Julie Boyer. She says, given how broad this provision is, it could include an employee of the juvenile detention center where the child is being held. So, Yolanda, that was the only comment.
Okay.
I did have one other comment about the interrogation, and we've got Terry to thank for this. So when they separated this out, one thing that they, I think, just forgot to add in was that under the current law, it specifically says that for anybody, any juvenile who's interrogated, that the parent, guardian, or custodian can't waive their right not to speak. Well, that has been now removed basically from the 16 and 17-year-olds. I don't think that was intentional. I think that just sort of happened during the various versions, going through. And I also brought this up to some legislators. So again, hopefully we can get that rectified at some point. But I just wanted to point that out. If you've got a case where you've got a 16 or 17-year-old and somebody waived on their behalf, feel free to contact us and we can talk through that. But I think that's a problem.
Well, so the next kind of topic is other juvenile justice modifications. And so with these, as Eric was kind of saying earlier, this bill originated as DJJ's bill. It was their bill that kind of addressed their agency needs, but during the legislative session, there were a lot of other laws related to juvenile justice that were happening, and so all the other things kind of got combined to this one bill. But these particular modifications are related to their agency, and the first one is service of summons. As far as we know it, DJJ has always had the ability to serve summons and serve a juvenile, but this codifies it for them. So they are allowed to serve a summons upon a juvenile. The second change is comprehensive clinical assessments. For the most part, what they are, when they're recommended, doesn't change. The biggest change here is the time period. And so, as you know, in practice, CCA, you would have to have it would need to be made within the last 45 days for it to be valid and to be reviewed. This particular provision changes that from 45 days to 90 days to give a little bit more time and usage out of a CCA. So that is meant to kind of help the court process with that. And then DJJ is also required to implement minority sensitivity training. And it says DJJ is responsible for creating, implementing, and evaluating their training, and they must conduct these annually. And so at DJJ has a DEI coordinator who collects all of their data and does trainings on it. But this part of their modifications kind of codifies that as well. Eric, anything you would add? Okay. All right. So the next change is kind of an interesting change. I think alluded to a little bit earlier, and it's related to secure custody orders. What it says is that an initial secure custody order may be issued after the filing of the petition, but before the juvenile has been served with their petition. You know, this, I guess, in some counties happens that a kid is taken into secure custody based upon a filing of a petition, but the secure custody order execution and the service doesn't happen at the same time. And so the juvenile is in secure custody but hasn't been served. I think that there have been some issues letting that happen at the same time. And so now it says if a juvenile hasn't been served with the petition after being detained, the juvenile must be served within 72 hours after being detained. The only other change in that section that happened was that it says that execution of a secure custody order is now same as the real-time rules as serving an adult warrant or an adult arrest warrant. But the real big change is that a secure custody order may be issued without it actually being served at the same time. Eric, anything you would add to this section?
Not necessarily. If we talk a little bit about strategy, we can go over a little bit about the conversation we had yesterday.
Yeah, I think that you know, one of the issues with this is that we have been talking a little about if the juvenile isn't served when they're taken in secure custody, do they really have notice on their charges? Why is there the 72 hours prong? You know, there are kind of questions that we see or that come to mind when we see this language.
Yeah, I think what's a little different about juvenile court than adult criminal court is now you can be placed in secure custody because like an offense was committed right in front of you. But for a secure custody order to issue, you have to first have a petition filed. And once you have a petition filed, you have a lawyer. And so some of these rights, should really get started immediately. And it seems a little strange to us that, if you look at the secure custody AOC order, the first thing it says is, there's a reasonable factual basis to believe that the juvenile committed an offense as alleged in the petition. So, like, a juvenile could be given a secure custody order and not even know what they're charged with. So, and we know that notice, is one of the constitutional guarantees from In re Galt. So it's concerning that this is kind of being done seemingly because of expediency and not really, considering what is a core right of youth in our court. So, we've been talking about this. We're not exactly sure what the remedy is, but you might want to consider, objecting if you find out, you get to the initial secure custody hearing and you find this out and ask for, your client to be released based on the violation of their right to notice. I don't know. It seems very odd to us, and I'm sure some of you out there probably have some good ideas about what could be done. But as this is going on, like I said, let us know what you see out there and sort of what you've done to address it.
And so just for effective date, for most of the changes in House Bill 186, this goes into effect just next month in a few weeks on December 1st, 2023. There are some things that, the capacity section that Eric will talk about shortly doesn't go in effect until later, but most of those changes go into effect just in a few weeks.
So the capacity to proceed statute again. So this issue, just to give a little bit of background, came out of the Juvenile Jurisdiction Advisory Committee. We started talking about making recommendations about minimum age. The sort of corollary concern was that younger youth, any youth, but specifically younger youth, were not capable of proceeding. And as a result of that conversation, a lot of work among, the advisory committee, DJJ, DHHS, a lot of it in the legislature, a lot of individuals came together to talk about and formulate an actual capacity to proceed process. Anybody who's tried this in juvenile court knows that we have kind of a secondhand adult criminal procedure that hardly addresses any issue. So I'm looking at the statute, and this is part 5, starting on page 6, and you will see it is an entirely rewritten process about capacity to proceed. It includes, the procedures, and what's, admissible in the hearings, um, an actual forensic evaluation process and who's eligible to do that, um, a remediation process that kind of existed but not really, um, and then what to do as a result of being found incapable of proceeding. Are they committed? What's dismissal look like, and those kind of procedures. Um, and again, the reason why we're not talking about it now is you can see it's not effective for another year. There also has to be some funds allocated um, to work out sort of the behind the scenes machinations of this. But once we are convinced that it is online, we will do a separate webinar just on this because it's so radically different. So stay tuned for that. Okay, let me just pause there. Still any questions, thoughts, comments? Okay. So the Pretrial Integrity Act, this law that most people already know about, largely affected adult adults charged with criminal offenses. Um, but there's a couple pieces in here that we need to look at. So the uh, the first piece of this, remember when I was talking about the 13, 14, and 15-year-olds charged with a Class A felony? Well, this has now been impacted for secure custody. And why it's in this statute, we don't know, but it is. And what it says is that further hearings um, to further secure custody hearings are now every 30 days, just like they are for 16 and 17-year-olds charged with offenses that can be indicted. So again, we're not really modifying raise the age per se, because these are 13, 14, and 15-year-olds. But those procedures for the Class A felonies are starting to look a lot like the procedures for 16 and 17-year-olds in that raise the age group. So this is the other change. So now continued secure custody hearings are every 30 days, but it provides that attorneys can always ask for a 10-day review, just like is happening now. And just to note again, there's nothing for 16 and 17-year-olds. This is stayed the same, and there's no changes to that.
So with this, we wanted to just put in some of the provisions or changes that affect adults, because some of them may affect some of the clients you represent. One of the changes is that when there are clients or defendants that are out on criminal charges and they are already out on pretrial release and they pick up a new charge, the statute says that a magistrate can no longer review conditions of release for those new charges, and a defendant can be held for up to 48 hours waiting for a judge to make that determination. Again, we put this in here because we know a lot of you represent, 18 to 25-year-olds are adults, but it really affects the adult criminal population. This next section, however, is really important for juvenile defenders to know, because what this section does is now it says that judges must set the initial bonds for the following offenses. And it lists a whole bunch of serious felonies in the statute. But what it also does is give them the discretion to set no bonds for these cases. And so where that used to be only applied to murder and first-degree murder, now it's applied to all of these different offenses. And so if a judge felt that a no bond needed to be set for assault with a deadly weapon, intent to kill, serious injury, they could, for example. Why this is important for us is that when we have kids that are transferred on these offenses and you have that initial bond hearing in juvenile court, it's important to know that a judge could set that no bond. And when it goes to Superior Court, you may be trying to kind of fight that no bond condition there, or a Superior Court judge could set that. And we all know that a lot of our young clients get charged with robbery with dangerous weapon, for example, assault with the intent to kill, for example, burglary, arson, and all of those are on this new list. As we said, though, with the Pretrial Integrity Act, it has been implemented now for about a month. The effective date on that was October 1st. And so I know that it's been happening in practice. And so I'd be definitely interested to hear from you all to see how it's been going. But the big takeaways, again, are that youth 13, 14, and 15 charged with murder will now have up to 30 days between secure custody hearings. Transport youth with one of those listed charges may have no bond set as a condition of release. And again, if a defendant is out of custody pending trial and picks up a new charge, they may be held for up to 48 hours before having a bond set or being released. Hasn't anybody have any questions on this one? Okay.
Okay, so school threat assessment teams. So I think, as most people on this call know, there seems to be, you know, um, higher occurrence of youth being charged with um, communication of threat of mass destruction in schools, communication of false threats. Um, there's a lot of, I think, societal concern about kids and the potential for threats or violence at school. So the legislature for a number of years had been talking about creating school threat assessment teams. I think in some jurisdictions this already exists. So we'll be glad to hear from anyone who's already got one of these happening. But now this is sort of an official kind of statewide, here's how you put these groups together. And so what it does is it brings a combination of school administration, mental health folks, law enforcement, who are supposed to look into um, some of these charges before they're charged, some of these concerns. Um, and then as a result of them getting together and reviewing information, they would recommend certain action. The Center for Safer Schools is supposed to be putting um, some general rules together or other guidance to follow for local school boards. Um, but and our information is, I think they've sort of started to do this, but I don't know if anything official has been completed. And these teams and the plans are supposed to start the fall of next year. So they do have a little bit of time to put those together. So everybody's familiar with the SROs in schools. I think there is some concern that this will now be heightened. Um, Again, I know folks have represented youth out there who have been charged for, making a one-off comment or texting somebody or posting something on Instagram, um, which was not, ever meant to be anything serious. So our concern is that now there's going to be even, more scrutiny, and sort of more official scrutiny. Um, and even though there's like statewide guidance, we think this is going to be, um, executed very locally. So it may behoove you to kind of figure out how this is being put together. Um, it would be great if they would consult with us, but we're not on this. But Disability Rights North Carolina is, so we're hopeful that they're going to have some good points to make. And the other thing about this is, so say down the road your client gets charged and you hear about, um, you know, that there was a threat assessment team. How do you get this information? Um, it's unclear if this is going to be part excuse me, of juvenile justice's record. Um, is it part of the DA's record? We don't know. So we don't know if it's discoverable or what. So you may want to start thinking about, filing subpoenas in these cases to get this information. Um, so uh, just be on the lookout for this. And this is also for offenses committed on or after December 1st. Well, the effective date for most of what we talked about, except for the Pretrial Integrity Act. We also wanted to mention the Parents' Bill of Rights. This is allowing parents information about what their child is saying and doing in school. I think we know that sometimes our clients will go to school and maybe use different pronouns, maybe dress differently, as they're exploring their gender identity. Well, this requires educators to disclose this information. And the reason we think this is relevant is because, this can lead to possibly some trouble at school. It could also lead to potentially conflict between the youth and the parents, which may lead them to be acting out at home or running away. So we just wanted to make sure everybody was aware that this bill exists.
Eric, Jane,
All right.
Jane
Yep.
Weatherly put in the chat to everyone back to the secure custody order, and this is sort of a good place, I think, to weave that in. Without
Right.
service of a petition, doesn't a parent have a right to know why their kid is picked up on a secure custody order and have notice? Especially given this parent's Bill of Rights that is coming up as well.
Well, you could maybe tie the two together. I don't know that the security custody statute was altered the parents' notice. Parents aren't guaranteed constitutional notice, but they are statutory notice. But it's an interesting point about, well, if we're supposed to know everything's going on in school, but we can't know what our kid is charged with, that could be problematic. It's a clever way of looking at it. What else? What other questions? So I'm sending in the chat the links to the 4 bills we discussed. And I believe that we have another resource in the pipeline. Right, Yolanda? Is there something we're putting together?
Yeah, so Nani, our communication specialist, is working on some infographics that hopefully we'll be able to print out and, put as handouts so you can take it with you as well, but it'll give brief overviews of all of those substantive changes in House Bill 186. So there'll be an infographic for transfer, an infographic for public disclosure, and an infographic for the changes, those big substantive changes that you can carry around with you.
And Yolanda, we could probably, we'll put that on the website, on all our usual channels, but is it possible to send that to everybody who's on the webinar today?
Yes, we can.
Okay. And we'll get that done in the next week or two. We've already gotten a couple of drafts, and I think we're close to being completed. All right. Any other questions or thoughts? Well, before we totally sign off, I'm gonna do a little plug. Eric likes plugs. If my computer will work, which it's not. So I know a lot of folks are aware that we are starting to build our juvenile first-degree murder roster. And if you don't know about it, I'm going to paste in the chat the application. Please feel free to contact us. We're very excited. We're We've already got some great folks who have applied, and if you have any interest in doing this work, please feel free to reach out to anybody in the office, but especially Berja, who's sort of putting the roster together, but me or anybody else. And if you would please fill out our evaluation. We learn a lot from your feedback to how we can make these better. So please do that. Yolanda, anything else?
I just have, before folks go, I'm just curious, since we have a lot of different folks on the call, for the folks who are working in the courtroom, how is the Pretrial Integrity Act how's it going? Are judges doing more no bonds now because that's possible, or are folks having to stay in custody a little bit longer if they have pretrial release violations? This Christian in the chat says that first appearance dockets are a nightmare.
How so, Kristen? Oh, yeah.
And Jane in the comments said, yes, absolutely staying longer, and the hurdles that the statute requires to rebut for presumption are basically impossible.
Are folks seeing this specifically with youth clients that have been transferred? Is anybody seeing kind of a bias or anything for, I mean, certainly 16 and 17, but even younger? Yes.
Well, this is helpful for me to know as we as we develop future trainings on this. It's just helpful to know how we can tell people that how it's happening in practice, so we can advise people and give them even more tips and strategies.
Chelsea, can you tell us?
Can I ask a
Go ahead,
question?
Julie. Of course.
Okay, well, yes. So some people are typing. I just figure it's easier to, ask. So honestly, I have no experience with the Pretrial Integrity Act since I had surgery on October 3rd. So that's the only delightful thing about that. But with that caretaker provision, I was asked by a civil attorney, what possible liability could a detention officer have at a JDC if they stand in as the caretaker because they are responsible for the child's well-being? And, is there an issue of civil liability? Are detention center directors, do they have parameters? Does DJJ have parameters as to not allowing them to stand in as a caretaker? Because under that new statute, the person that is keeping you in custody has every ability to be your caretaker in a custodial interrogation.
We've talked to DJJ about these quite a bit, but that has not come up. I think for sure if either, sort of the floor worker or the detention center director stands in, they're clearly witnesses. And I'm guessing that's not something DJJ necessarily wants to get into. So I don't know how that would be worked out. I think, law enforcement has different relationships with different centers, and I think that's part of it. But no one has mentioned civil liability yet, so that's a good point.
I will continue to mention it if it helps keep my kids from being interrogated in custody with a freaking detention officer as their custodian.
That's a good plan. So Chelsea was typing in the first thing the judge talked about in chambers. Was this, Chelsea, was this like just part of a regular like bond hearing, or was this right after somebody was
So just to
transferred?
set the stage in Randolph County, I'm sorry, my voice sounds awful because I just got
Go ahead.
over being sick. So in Randolph County, we have the Department of Social Services court on Wednesdays. And I've been filling in as a conflict attorney for the Guardian Line program. And with those hearings being on Wednesdays, if there's some type of detention hearing that needs to be held and could not be done on Monday with juvenile court, they allow it to be done on Wednesdays. And so I just happened to overhear this, because I was in court that day. When I first walk into chambers, we're all talking about the new statute. And that's the first thing that the judge had spoke about, that, this and that the school of government is providing now, that the juvenile, what we've been doing in practice is having that person consent via WebEx, because they're not wanting to bring juveniles under these charges anymore, at least to our county. So they're keeping them in the locked facilities in these secure hearings. And so in practice, we've always asked them if they consent, or therein lied the question, what if they don't consent? So now the school of government has provided information that if they don't consent, then you can't have the hearing and there has to be a way to bring them. And so that brought up a whole nother line of questions. But in this particular instance, the child did consent. And they said, you're going to be in there for at least another 30 days. And in practice, it's always been 10. So the attorney was kind of caught off guard because he didn't know about the statutory changes. And I said, well, I'm about to have a CLE on this weekend. I might be able to fill you in a little bit because, it hasn't been widely advertised, which I think in all fairness, we all have our due diligence to go check. But this is a major change to what we've been doing in practice, in my eyes. So when I say it's the first thing the judge talked about, it kind of shocked him in practice, how everything is going to be changed from this point going forward.
And that's why we're having this webinar. Tell your friends and neighbors. Do we know if is this going to also be available online later on?
Yes, it is being recorded and will get uploaded.
So we can, when we send out these other materials, we can send out the link to it as well. I know that Jackie Green at the School of Government has actually been doing a series of blogs about this to the judges, but like you said, I mean, they've got a lot of other issues and things pulling at them, so they may not have been paying that much attention. And quite frankly, a lot of this sort of went under the radar. I think it got a lot of attention early on because some of the earlier versions of these bills really kind of attacked raise the age. And then when a number of people who did not support that got involved, it got watered down, but not to the point where some of these concerning pieces were fixed or eliminated. So, like I said, it's kind of what we're left with. But I do, when you're talking about due diligence, I do encourage folks to look at the links and check out the statutes for yourself. But we will have that guide for you soon, so hopefully that'll be helpful.
And Eric, just so you know, there was a modification, and of course, they name statute or they name House bills and all that stuff, but they have 8 million different things in them. The Innocence Inquiry Commission modifications actually modify 15A-211, which has to do with interrogations, custodial interrogations, recording of interrogations, and things like that. So it does actually modify 15A- I think it's 211, just offhand, but to actually provide more recordings of interviews and things like that. And that has come out of a lot of the false confession cases where you have a 6-hour interview and a 3-minute recording. But so yeah, those do also affect our kids as well. And so if you get a recording of an interview and you don't see it from the moment they start, then that's a concern.
And so, Julie, that sometimes it does, and sometimes it doesn't. Does it expressly say juvenile interrogations as well? Is
It
the same
does,
statute?
and that's
Oh,
why,
great.
yes, because it came out as directly as a result of the Forsyth County case where the
Right.
5 intellectually disabled children were threatened with the death penalty, interrogated over the course of hours and hours and hours, and gave 5 different statements. However, those 5 statements could not be reconciled with each other or with the actual evidence, so only certain confessions were played at trial. And so it does specifically mention juvenile interrogations. And so, yes, it's certainly something to pay attention to.
Well, we get some good things and some not good things with interrogation. So thank you for bringing that up.
Well, I think unless there are any more questions, we will send out a copy of the PowerPoint to everyone so that you can have it, the resources that Eric mentioned, as well as a link to how to get to the recording of this as soon as that's available as well. But before I end us, any last minute burning questions? Well, thank you so much, everybody, for coming today. We hope that it was helpful to get kind of an overview of some of the changes. We will submit our CLE in the next couple of weeks, and hopefully that'll show up on your record pretty quickly.
Thanks, Yolanda. Thanks, Nane, for putting this together, and thanks everybody for attending. We appreciate it.
Thank you.
Thank you.